This is Bloomberg Law with June Grasso from Bloomberg Radio.
Through his executive orders, President Donald Trump is making a broad push to reshape the federal government and centralize power in the White House.
Don't forget, I got elected on the basis of making our government stronger and smaller, because we have millions of people that obviously they're paying millions of people that shouldn't be paid.
And this week, in an unprecedented power grab, Trump issued an executive order declaring that he has direct control over some of the country's most powerful regulators. Dozens of independent agencies, like the Securities and Exchange Commission and the Federal Trade Commission, that were designed by Congress to operate without day-to-day oversight by the White House, but now, according to Trump's latest order, will have to submit to oversight over rulemaking, policy agendas, spending, and interpretations of the law. Like many of Trump's executive orders, it's sure to face legal challenges. My guest is regulatory expert Carrie Colanesi, law professor and director of the Penn Program on Regulation at the University of Pennsylvania. Carrie, the president already appoints the heads of these agencies, and a majority of the commissioners are members of the Republican Party. So aren't their ideologies already aligned with the president's?
Once you have the majority control on a commission and they're appointed by the president, they are coming in with an ideology and a predisposition to do the sorts of things that the president wants anyway. So as a practical matter, these agencies are not as totally independent as maybe the label an independent agency might make them seem. This executive order, though, eliminates, at least it's claiming to eliminate, the kind of hands-off approach that, quite frankly, many presidents have taken with respect to some of the very institutionalized review processes of having budgets not reviewed by the White House, of having regulations not reviewed by the White House. This administration is now claiming, well, we're not only going to have our loyalists heading these agencies, but we also want to scrutinize your budgets. We want to scrutinize your strategic plans. We want to scrutinize your legal decision-making. We want to scrutinize your important regulations, just like we do the Department of Transportation, just like we do the Department of Labor. All of those are agencies that are headed by folks that have been appointed by the president, too, right, and share the president's objectives. But, sometimes, you can get heads of these agencies that have viewpoints that do depart a little bit from what the White House wants, or heads of agencies that are not as vigilant about carrying out the president's agenda. And these institutional processes that the Trump administration says now it's going to apply to the independents are there to try to really put the hammer down and make sure that agencies follow what the White House wants them to do.
And how does this order treat the Federal Reserve?
Well, it brings the Federal Reserve as a regulator under the ambit of the executive order, but it specifically exempts the Federal Reserve in its exercise of monetary policy decision-making from White House scrutiny and oversight and control under the executive order. So at least for now, and this is a good thing for the country, the Federal Reserve's monetary policy is supposed to remain independent and free from political interference from the White House. Not so with respect to, say, the banking regulatory functions of the Federal Reserve, at least as this order is now drafted.
What are some of the dangers of a president taking control of independent agencies like this?
To the larger issue, about what we're getting and what we're losing, I think all agencies, whether they're executive branch agencies or independent regulatory agencies, need a degree of autonomy from the kind of raw politics that can often be important to presidents, and I think are clearly important to this president. We don't want a government where agencies are acting on impulses of favoritism or retribution. And some presidents might want that. This president might want that. And if we don't have a degree of autonomy in our governmental institutions from that kind of raw politics, we will really suffer as a country.
This is all part of the theory of the unitary executive, which gives the president sweeping powers, sole authority over the federal government's executive branch. And the speculation is that the Trump administration wants to push the Supreme Court to adopt the unitary executive theory.
Right. They're basically acting as if the court has already adopted wholesale the unitary executive theory by, in effect, overturning the 1935 Supreme Court decision called Humphrey's Executor. That decision, the Supreme Court said that Congress can create these independent agencies that are headed by officials who have some kind of tenure protection and can't be removed at will by presidents. This administration is taking action that one would expect to see if Humphrey's executor had already been determined to be unconstitutional. They're, firing already some officials at the NLRB that have had good cause protections and taking other actions like this executive order that are very aggressive. And I think they're setting up and hoping that they'll get the Supreme Court to overturn Humphrey's executor. It wouldn't be a big stretch to expect the Supreme Court will do that. The Supreme Court's been whittling away at Humphrey's executor for easily 10 years or so now. And, it's probably expected by most observers to be on the chopping block. The big deal will be if Humphrey's executor goes, will it go big time? That is by sweeping in civil service protections and protections for the Federal Reserve's monetary policy? Or will there be some way that the Supreme Court says, well, it's unconstitutional for Congress to create insulation for every other position in government, but we still think it's okay for civil servants to be protected with some good cause protections, or for the Federal Reserve when it's adopting monetary policy to have that. Hard to know exactly how the Supreme Court will decide when this case comes before us, but I think it's headed there, and this administration, I think, is already acting in effect as if it's been there and they've won.
Do we know which Supreme Court justices are fully behind the unitary executive theory?
Well, I think there's probably a good majority that are inclined to this. I mean, Chief Justice Roberts even has been kind of spearheading decisions to whittle away at Humphrey's executor, going back to decisions that first started to say that we couldn't have sub-agencies that have good cause protection if the head agency did. That was held to be unconstitutional. Then it was held that you can't have a single-headed body that has an administrator that's got good cause protection. So there's a clear majority that looks suspiciously on these. They've just been moving incrementally and maybe waiting for the case that will take it to the next step.
I don't understand why a judge would want to give more power to the head of the executive branch, unchecked power. I would think they'd want to keep more balance between the branches of government.
Yeah, if you look at a lot of the cases over the years, and there haven't been that many, but when these issues have arisen, the courts have been suspicious of Congress's power, believe it or not, and Congress's power to kind of interfere with the administration of government by putting in place limitations on who can head up agencies or how they can be removed. And I think there's been some sensible decisions that have said, Congress, you can't pick who are the heads of agencies, or you can't yourself have a role in deciding whether an agency head is removed or not. But, now those cases and the suspicion of Congress is sort of going to the extreme. And, we do have justices on the court who have spent time, like Justice Roberts and Justice Kavanaugh and so forth, who have spent time working in the White House, and maybe that has emboldened them to think in presidentialist terms. There's also, I think, a mindset of sort of formalist, rigid, hierarchical authority that some of our justices in the majority seem to exhibit, that they think that there should be just one person at the top of the executive branch who should get to say everything that the government does and have the ability to shape the course of all policies. Now, that's not really, I think, how the text of the Constitution is necessarily written. There are actually no provisions in the Constitution dealing with the removal of officials. So, it's not something that's demanded by the text of the Constitution, nor is it really in our history, whether at the time of the founding or subsequently, to say that Congress can't create bodies that have some degree of autonomy from the president.
Finally, what about Doge? It's acting like an agency, but it's not an agency. Is there any problem with that?
Oh, sure. There's all sorts of problems, but, there are problems that are kind of unprecedented, and they're trying to be real stealth-like with this. We don't have a lot of transparency what they're doing, and they're moving very quickly. The courts are not prepared to do very well with things that are done in secret and that are done fast. They're trying to do a lot with data and fear tactics, and those are very hard to combat through the court system. But it's very unprecedented, and it may be hard to resist in a real time, and this is moving very quickly. So right now, the administration's claiming that Doge is really just acting as advisors, but I think, factually speaking, that seems not to be at all the case. I think one step that litigants will have to do is sort of pierce through that characterization and show what's really going on. This is what you see if you don't really care about making meaningful, smart management decisions. And there should be no denying that there's ways we could improve government and streamline and make more efficient government processes. But there's very little indication that that's really what's motivating Doge or the president, for that matter.
Thanks so much, Carrie. That's Professor Carrie Colanisi of the University of Pennsylvania Law School. Coming up next, will the Supreme Court have to face its greatest fear? I'm June Grasso, and you're listening to Bloomberg. Unlike the executive and legislative branches of government, the Supreme Court has no real power to enforce its decisions, no army or constitutional spending power to use as a cudgel. So what happens if the President of the United States refuses to comply with a Supreme Court order? Basically nothing. Something Vice President J.D. Vance pointed out on the Jack Murphy podcast in 2021.
I think that what Trump should do, like if I was giving him one piece of advice, fire every single mid-level bureaucrat, every civil servant in the administrative state, replace them with our people. And when the courts, because you will get taken to court, and then when the courts stop you, stand before the country like Andrew Jackson did and say the Chief Justice has made his ruling, now let him enforce it.
A president hasn't defied a Supreme Court order since the Civil War, but Donald Trump seems to be ignoring long-standing legal constraints, testing the limits of his power. Is the next step refusing to comply with a court order?
The answer is I always abide by the courts, always abide by them, and will appeal.
Though Trump says he'll abide by court orders, his Truth Social posts and key aides seem to be suggesting defiance. Will Trump force the Supreme Court to face its greatest fear? What to do when a president says no? Bloomberg Supreme Court reporter Greg Storr has written an essay on this question, and he joins me now.
You wrote this article, and it's very scholarly, Greg, and it reminds me of being in law school in a good way. And you start with the history of the landmark case known to every lawyer, Marbury versus Madison,
which established the principle of judicial review.
Yeah, this is probably the most important case in the history of the country. Written by Chief Justice John Marshall, as you said, it established that the court has the power to strike down acts of Congress. But what's notable is how Marshall got to that conclusion. The case is about when John Adams left the presidency after losing re-election. On his way out the door in 1801, he appointed a bunch of judges known as midnight judges. And kind of in the frenzy of doing that, with one of them, a guy by the name of William Marbury, the final step of paperwork didn't happen. The commission didn't get delivered to Marbury before Adams left office. Then Jefferson comes into office, and his Secretary of State, James Madison, refuses to deliver the paperwork, even though that's a pretty routine step. So Marbury goes to the Supreme Court and says, hey, order Madison to turn over that commission. He's violating the law by not doing that. And so John Marshall has this dilemma here. The Supreme Court's new hasn't really established itself. The question is the Supreme Court going to order Madison and the Jefferson administration to turn over that commission to Marbury? And the ingenious solution that he came up with was, hey, we don't want to risk the possibility that Jefferson and Madison won't comply. So instead, we're going to say, yes, Marbury is entitled to the commission, but as it turns out, we don't actually have jurisdiction to decide this case because this law that Congress passed giving us jurisdiction is actually unconstitutional. So Chief Justice John Marshall ducked the confrontation with Jefferson while establishing that the court is this very powerful institution.
Marshall's fears that a president wouldn't comply with the court's order came to fruition during Andrew Jackson's administration.
Jackson, who, by the way, is one of Trump's heroes, refused to enforce a Supreme Court ruling, basically that the Cherokee Indian tribe had a right to live on their land in Georgia, leading to the infamous Trail of Tears. But actually, it was President Abraham Lincoln who went even further than Jackson in a clash with the Supreme Court's Chief Justice, Roger Brooke Taney, during the Civil War.
Yeah, this is probably the closest the president has ever come to directly defying the Supreme Court. The war had started, precipitated in part by the Supreme Court and Chief Justice Roger Brooke Taney issuing the Dred Scott decision that declared that freed slaves could never be citizens in the United States. And as the war starts, Abraham Lincoln is very concerned about sabotage, and he issues an order that authorized one of his generals to suspend the writ of habeas corpus near railroad lines in Maryland. And habeas corpus is this notion that if the government holds you, arrests you, you can go to a judge and make the government defend why it's holding you. And Lincoln said, we're going to suspend that because of the crisis we face here. Well, the guy named John Merriman was arrested, turned to Roger Brooke Taney, got a writ of habeas corpus anyway, which demanded that the military justify why Merriman had been picked up. And Lincoln and his generals essentially ignored the order. Merriman did not go before a judge. And Roger Brooke Taney eventually said, look, I've done all I can do here, but he said, my power has been resisted by a force too strong for me to overcome. And Lincoln later justified what he did, saying, are all the laws but one to go unexecuted, and the government itself to go to pieces, lest that one be violated? In other words, he said he was justified by the exigencies of the circumstance, namely the Civil War.
Since Lincoln, presidents have complied with Supreme Court orders, and Richard Nixon turning over the secret White House recordings in 1972 is the most recent incident and probably one that people remember most. But tell us about some of the other presidents who chose not to defy a court order.
So there's a litany of examples, a few of the biggest ones, just because of how high profile the cases were. 1952, President Harry Truman seizes the nation's steel mills to make sure there's not a work stoppage during the Korean War. Supreme Court rules against him, says he did that illegally. Truman immediately complies. In 1954, the Brown versus Board of Education decision and some subsequent rulings, President Dwight Eisenhower, initially reluctant to get involved, but actually helped the Supreme Court enforce those rulings, and the lower courts enforced those rulings when he sent federal troops to escort black students into a high school in Arkansas. And then 1974, Supreme Court orders Richard Nixon to turn over secret White House recordings. Nixon complies. Days later, he has to resign the presidency.
So you asked this question in your piece, and so now I'm going to ask you for the answer. Why are presidents so quick to accept Supreme Court rulings as binding?
Well, there are both specific answers to each instance and kind of a general answer. And the specific answer is often when the president is taking a very unpopular position. Harry Truman's position, for example, very unpopular at the time, and his standing was especially low. But there's also the more general answer, which is that the court over the years, the decades and centuries, has earned some trust with the public. It has institutional standing that, at least until recently, was pretty strong and very often stronger than the other branches of government. And that goodwill has essentially created what some call a habit of accepting the Supreme Court decisions, even when folks disagree with them.
You said until recently, because the court has lost its high standing with the public.
It's not quite at its lowest now. It has recovered somewhat, but it did hit bottom just a couple years ago after the Dobbs ruling that overturned the constitutional right to abortion.
President Trump has said that he'll obey court orders, and he did in his first term.
But he also has said some things that leave a question mark in the air. For example, he posted a quote that's been attributed to Napoleon Bonaparte. He who saves his country does not violate any law.
So is there still a question about whether Trump will follow Supreme Court orders?
Absolutely, there's a question. The administration is clearly sending out mixed signals about its intentions here. You talked about some of the things President Trump has said. There are also things that some of his top aides have said, like Vice President J.D. Vance, who actually quoted that apocryphal Andrew Jackson comment about the Chief Justice has made his ruling, now let him enforce it. Elon Musk has said things that have strongly suggested he would be willing to defy the Supreme Court. So that concern is in the air in a way it has not been in my lifetime. Even in those moments of huge national crisis, major Supreme Court decisions like the Nixon tapes case, there wasn't this level of concern that a president might just thumb his nose at the Supreme Court.
And he has issued a lot of executive orders that either ignore the law or defy the law.
For example, the funding freeze and the order to end birthright citizenship, which 4 out of 4 judges have found unconstitutional.
So is it almost a deliberate defying of the legal norms?
So let me separate two things. With birthright citizenship, what we have seen this administration do is start off by just ignoring what has been the long-standing understanding of the 14th Amendment and acting as though birthright citizenship is not guaranteed. But once court orders have come through, they are complying with them. But in other contexts, the administration has, for example, with an order to unfreeze federal funding, the administration has been a little less quick to comply, and in one case has prompted a judge to issue a follow-up order saying, hey, I really expect you to unfreeze that funding. So this is playing out in a lot of different cases, and we haven't yet got to that point where I would say we're at, say, a constitutional crisis, but there are at least hints that we could have a big issue down the road.
Greg, I have to say I find some irony here in the fact that it seems like the Supreme Court has made its own bed with that ruling in Trump v. United States last term, granting immunity to the president for official acts. I mean, that ruling was stunning, and administration lawyers are now quoting that opinion to demonstrate their points about presidential authority.
Yes, there's a case that, in fact, the Trump administration's first case at the Supreme Court in this new term, asking the court to let him immediately fire the head of a whistleblower agency. That brief was chock full of citations to Trump versus United States, the case you talk about, the immunity case, basically saying that the president has broad authority, complete authority over the executive branch of government. And what they're arguing is the Supreme Court has said that the president is the head of the executive branch and can fire people when he deems it to be in the country's best interest. And that ruling has put a fair amount of wind behind Trump's sails in making that argument.
That argument didn't get the administration too far because on Friday night, the court declined to let Trump oust the head of the federal whistleblower agency. But with a bare majority of 5 justices, the court neither granted nor rejected the administration's request to immediately remove him. Instead, the court held the request in abeyance, noting that the order expires in just a few days, this coming Wednesday. 2 of the liberal justices, Sonia Sotomayor and Ketanji Brown Jackson, said they would have rejected Trump's request, while conservative justices Samuel Alito and Neil Gorsuch said they would have granted his request. The lower court judge has scheduled a hearing for Wednesday on whether to extend her order, keeping him in the post. So the justices could return to the case, depending on what she decides. So sort of a non-ending ending. Thanks so much for joining me on the show, Greg. That's Bloomberg News Supreme Court reporter Greg Stohr. Coming up next, Johnson & Johnson tries for the third time to use bankruptcy to end thousands of lawsuits. I'm June Grasso, and you're listening to Bloomberg. Johnson & Johnson, one of the most profitable companies in the world, has put a very small unit into bankruptcy to drive a $10 billion settlement of thousands of lawsuits alleging that its baby powder caused ovarian cancer. J&J wants to use special rules available only in bankruptcy court that pause all lawsuits. The company has tried this twice before, but has been stopped by courts in New Jersey and Pennsylvania. The Third Circuit Court of Appeals ruled that bankruptcy wasn't warranted because the bankrupt unit ultimately had the backing of its deep-pocketed parent. Now, in its third try, J&J is betting on a different result from a Houston, Texas court. Joining me is Stephen Church, Bloomberg bankruptcy reporter. This case has a long and complicated history. Tell us how we got to this point with a trial in Houston, Texas.
For the last 10 years, Johnson & Johnson has been fighting allegations that tainted baby powder, something that has asbestos in it, allegedly, causes ovarian cancer and other gynecological cancers in women who use this powder just about every day. Those lawsuits have slowly been building. There have been more and more of them filed. Now, there are about 60,000 lawsuits that have been filed and another 25,000 or so claims that have not yet been filed in court but are still being prepared by lawyers. The company has fought them throughout the entire time and has refused to settle and has claimed repeatedly that there is no scientific link between baby powder and other talc-based products and cancer. The problem is they've had at least one major verdict that went all the way to the Supreme Court, forcing Johnson & Johnson to pay out more than $2 billion to about 20 women. That got the company's attention, and they tried to find a new way to resolve these all at once. That new way, just a few years ago, was to go into bankruptcy court. They took a small unit and made this unit responsible for paying off all the talc claims. Then they gave this unit a contract that promised that Johnson & Johnson would cover all the expenses. They've tried this 3 times. The first 2 bankruptcy cases of a unit of Johnson & Johnson where they tried to create this settlement failed. They're now on their 3rd attempt, and this 3rd attempt has gotten further than the other 2. They're after an actual trial where a judge will decide whether the plan to pay $9 billion out is legitimate or has fatal flaws that cannot be approved.
There are many attorneys handling these cases, and they're fighting. Some want the settlement, some don't want the settlement.
Correct. There are about 24 or so prominent attorneys who represent tens of thousands of women who have some sort of health issues that they claim came from the baby powder or related products. Most of those attorneys have settled with Johnson & Johnson in this 3rd effort, and they have agreed that a trust fund with $9 billion in it will be set up to handle almost all of the talc-related claims. There may be a few hundred that are exempt, but almost all of these claims will go to a special trust where they have rules set up to decide who gets paid and how much they get paid. Holdouts, a handful of attorneys who represent several thousand women, object. They say there isn't enough money and that the plan itself is flawed and legally can't be justified.
What made it different this time around was that Johnson & Johnson got pre-approval from a majority of the claimants.
Yes, Johnson & Johnson made a couple of changes in between their 2nd failure and this 3rd effort. After a Philadelphia Federal Appeals Court rejected their 2nd attempt to win approval of this trust fund, Johnson & Johnson negotiated heavily with many of the plaintiffs' firms and got a new deal. They added more than $1 billion on top of the original offer, bringing it to $9 billion. And they also did something that happens in many bankruptcies, big, giant bankruptcies, where they took a vote of all of the claimants in order to pre-package the bankruptcy case. They wrote the plan, they developed the trust, and they asked more than 80,000 women to vote in favor of it. Many of the women did. Most of the women. Johnson & Johnson claims that more than 75% voted in favor of the plan. The holdouts claim that those numbers are not accurate because of some flaws in the way the voting took place. They claim Johnson & Johnson bought votes. They claim Johnson & Johnson counted votes in favor of the plan that should have been counted against the plan. And so that's a very technical aspect of this trial. Was the voting fair? Was it in compliance with these detailed rules that happen in bankruptcy court? Both sides have spent a lot of money fighting on this case.
Is that the main question that the judge is going to decide, or is he going to decide the fairness of this?
There are two big focuses. The one is the voting. Was the voting done correctly? Then once you get past the voting, there's another set of objections that might be even more serious. Those complaints are mostly coming from the U.S. trustee. That's the arm of the U.S. Justice Department that is a watchdog in corporate bankruptcies. Some of the holdout claimants, some of the holdout women who are suing also back this type of argument against the plan. And that is Johnson & Johnson is one of the world's most profitable companies. How is it possible that they can use these special bankruptcy rules that are designed for companies in financial distress, companies with serious financial problems, in order to cancel a bunch of debt and create this new trust? Johnson & Johnson argues, well, there's an exception. Under a law that Congress passed many years ago, cases that are about asbestos, if a company uses asbestos, which is a known toxic substance, in one of its products, and that company files for bankruptcy, then related parties, related companies can also benefit from that bankruptcy case. So in this case, the two big issues are, was the voting done properly? And then step back, should Johnson & Johnson even be allowed to take advantage of these bankruptcy rules if the company itself doesn't go bankrupt? Can they take advantage of this tiny little unit, put it in bankruptcy, and then the giant corporation gets the benefit?
Is the bankruptcy trustee afraid that this would set a precedent if Johnson & Johnson's allowed to do this?
There is that argument that this will encourage other very profitable companies to use sort of a loophole to avoid bankruptcy themselves. You can dump debt and eliminate these big lawsuits without actually going bankrupt yourself.
Was one of the first witnesses, one of the plaintiff's lawyers, talking about, the position that some of his clients are in?
Yes. What's unusual about this is that there's only been one major victory against Johnson & Johnson that made it all the way through the appeal process and that forced Johnson & Johnson to pay money to victims. What has happened until now is many of these cases have been stuck on appeal. So some women have won hundreds of millions of dollars, but those cases were overturned on appeal, and now there are still fights going on in state courts and in federal courts over whether some of these cases should eventually be upheld or rejected. That has stalled a lot of the plaintiff's lawyers from being able to move forward. So the net result is that none of these women have actually collected money from Johnson & Johnson other than that one unusual case that went all the way to the Supreme Court. One lawyer testified earlier this week that he has at least 20,000 women that he represents who haven't collected a dime yet. And his argument in favor of the case is this is the fastest way to get money to them. Put the money in a trust and then let the women go to the trust, explain their situation, fill out a whole lot of incredibly complicated forms explaining their health condition, how they got cancer, what cancer stage they're in, what types of ailments they have. And then a trust board will then decide, based on complicated rules, how much they get paid. That, this attorney and many of his allies argue, is the fastest way to get money into the pockets of women who have cancer.
Is it expected that this decision here would be taken up on appeal and then eventually end up at the Supreme Court?
Most of the lawyers in the courtroom in this trial have accepted the idea that there will be an appeal no matter what. Whether that appeal goes all the way to the Supreme Court is an open question. But the federal appeals court in Texas has a much different standard when it comes to certain kinds of cases and how you decide whether a case fits the law than the Philadelphia appeals court. So the assumption is that when this gets appealed, no matter who wins, somebody's going to go to the appeals court in Texas, the federal appeals court in Texas. And that's where a lot of the answers will come from. But even that could be appealed to the U.S. Supreme Court. And if that happens, we could see a precedent that other companies will try to take advantage of.
And that appeals court will be the Fifth Circuit, which is the most conservative circuit in the country and has often come up with, shall we say, novel theories of the law. Thanks so much, Stephen. We'll check back with you at the end of the trial. That's Stephen Church, Bloomberg bankruptcy reporter. In other legal news, the saga over the Justice Department's attempt to dismiss the corruption case against New York City Mayor Eric Adams continues.
After careful consideration, I have determined that I will not commence removal proceedings at this time. My strong belief is that the will of the voters and the supremacy and sanctity of democratic elections preclude me from any other action.
New York Governor Kathy Hochul said she won't remove Adams from his office at this time, but she plans to increase oversight of the mayor and City Hall, something she'll need City Council and legislative approval for. The Justice Department's order to drop the corruption charges against Adams led to the resignation of 8 federal prosecutors, including the interim Manhattan U.S. Attorney Danielle Sassoon, who raised concerns about a possible quid pro quo. Adams' cooperation in the Trump administration's immigration crackdown in exchange for dropping the case. And after a hearing last week on the government's motion to dismiss the case, federal Judge Dale Ho basically said, not so fast. He's appointing a prominent conservative lawyer, former U.S. Solicitor General Paul Clement, to examine the Trump Justice Department's move to drop the case, saying there has been no testing of the government's position. The judge's choice of the conservative Clement is an artful one. The former Solicitor General is perhaps most famous for defending a law against same-sex marriage before the U.S. Supreme Court, while Judge Ho is an appointee of former President Joe Biden and was formerly the director of the American Civil Liberties Union's Voting Rights Project. The judge asked for briefs to be submitted by March 7th and said he'll hold a hearing on March 14th if necessary.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.